This Thursday, February the 21st, 2019 meeting of the Alarm Systems Contractors Board. We want to welcome all our guests and staff here today. Ms. Vest, will you please call the roll?
Thank you. Scott Cockcroft.
Here.
Lou Richard.
Here.
Vivian Hickson.
Here.
Doug Fraker.
Here.
Keith Harvey.
Here.
You have a quorum, Madam Chair.
Okay, thank you. Have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Motion to adopt the agenda. Second.
Okay, we have a motion by Mr. Fraker, a second by Mr. Cockcroft to adopt our agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The agenda is adopted. Next are the minutes from the December the 6th, 2018 board meeting. Have the members had an opportunity to review those minutes, and if so, a motion to approve?
Motion to approve. Second.
Okay, we have a motion by Mr. Richard, a second by Mr. Fraker to approve those minutes. All in favor, voice by saying aye.
Aye.
All opposed? The minutes are approved. Next are the election of officers.
I'll do that part, Madam Chair. Thank you. At the first meeting of every year, we are to select or elect new board members for the chair, vice chair, and the secretary for this particular program. I have a little script here that I'm going to read, and I'll be filling it in as I do that. All right, we're calling for nominations for the chair for the Alarm System Contractors Board. Do I have a nomination?
Nominate Vivian Hickson.
Have a second.
Second.
Do we have any other nominees? If not, we'll do an election by acclamation. If the motion carries, do we have a motion for elect Vivian Hickson chair by acclamation?
So moved.
That was Keith Harvey. Need a second for that.
Second.
The second is Doug. All in favor, say aye.
Aye.
All opposed? Well, congratulations, Vivian Hickson. You're now the chair for the Alarm
Thank you.
Systems Contractors Board. Again. That was great. And I believe when I looked at the spreadsheet that this is your last year unless you get reappointed. You expire, I think, in December?
That is correct.
Okay. Still serving. Okay, we're going to do the same thing here for the vice chair. Do I have a nomination for the vice chair?
Harvey.
Second.
Have any other nominations? If not, we're going to do the election by acclamation. Can I have a vote on that? First, motion.
Motion to approve Keith Harvey.
That was done by Doug Fraker. Second by
Second.
Lou Richard. All right. All in favor, say aye.
Aye.
All opposed? All right. Keith, congratulations. You are the vice chair now of the Alarm Systems Contractors Board.
I have a question. We elect a secretary. I think all of it. Do y'all know what the secretary's position or response? I don't know. I'm asking. I don't know what it is.
Well, in this statute, it does say you have to have a secretary.
But I don't know.
The secretary, since actually the responsibilities, as the attorney says, is usually handled by us. That's why we took, and instead of doing the minutes ourselves, we got a court reporter. That helps with the secretary's position.
Also, I would say, I think I've seen in the past, since it is just a 5-person board and we need 3, the secretary would
Fill in
for the chairman.
It's the first two on here.
Yeah, to make
Okay.
a quorum, a board, yes.
Thank you.
Would be the chair. All right, we'll take the nominations for secretary for the Alarm Systems Contractors Board.
Cockcroft.
Second.
That was by Keith and second by Lou. Are there any other nominations? Not hearing any other nominations, we'll do this election by acclamation. All in favor?
Aye.
The motion, excuse me, the motion.
I'll do the motion.
Thank
Motion
you.
to approve Scott.
That was by
Second.
Doug and second by Vivian. All in favor?
Aye.
All opposed? Congratulations, Scott. You're now the secretary for the Alarm System Contractors Board. So now let me make sure I got this correct with my scribbling here. Vivian Hickson is the chair. Keith Harvey is the vice chair. Scott Cockcroft is the secretary for the Alarm Systems Contractors Board. Okay, thank you.
Thank you. The next item is Robert's Rules of Order. I don't know, the previous Mr. Roberts used to be our authority on that. I don't know if there have been any changes.
There have been changes.
Okay.
So the old way we would do that, we would vote for the Roberts Rule of Order with the exception that the chair could vote. Well, that Roberts Rule of Order has changed. Now it automatically says that the chair can vote. So all we need to do is adopt a Roberts Rules of Order.
Okay, I make a motion we adopt the Robert's Rules of Order as applicable to this board.
Second.
All in favor?
Aye.
All opposed? Robert's Rules of Orders has been adopted.
Okay. Next, Mr. Hoffman, you ready to shine?
Ready.
Oh, good.
Good morning.
Good morning.
Number one on the legal reports, 2018-070-561. Complainant alleges respondent is not licensed and advertises it has clients in Tennessee. Respondent states they have no person selling, servicing, or installing alarm systems in Tennessee, nor engaging in alarm system contracting. Respondent does not employ anyone or have offices in Tennessee. Respondent states they are an alarm servicing network that provides local contractors to a customer retailer, and if the retailer chooses the contractor, then they receive an invoice directly from the contractor. Research shows that Respondent is a manufacturer of security products and provides these products to several retailers for loss prevention purposes. After investigation, it was determined that Respondent provides burglar and some of the fire alarm monitoring for retail stores locations nationwide. This information was confirmed by the Director of Loss Prevention for Respondent. Further, Respondent has been providing monetary services for certain retail stores for over 7 years. The recommendation is authorized formal hearing and civil penalty of $5,000 for violation of 10 Code and annotated 62-32-304, subsection J, prohibiting the sale and installation and servicing of television or still cameras without certification.
Are they working to get licensed?
Not at this time.
Why would we be citing the still camera if the main thing you found was monitoring?
Well, they're actually installing the systems and monitoring. And if there's any problem with the system, the retail store is directed to call Respondent.
Back on my history, because they doing their own monitoring, or do you know? Or is it an outside company monitoring for the store?
It's a company that install it. They're installing the system in stores, in only certain stores, but it's not their company. Like, they don't own the retail stores.
Hired by the retail stores.
Yes, I believe that they're contracted by the company that owns the retail stores, and I would say that they're like exclusive.
So they're installing, but they're also subsequently monitoring and have been for 7 years,
Yes, in Tennessee.
without being licensed in any way.
There's no evidence that they have ever been licensed. They also do manufacture their products and install those products.
Somehow think that that afforded them an exclusion because they were the manufacturer, or
They never brought up any type of exclusion. They just said, we don't need to be licensed to the investigator.
why they thought they didn't need to be licensed?
According to the investigator, they just believe that they don't need to be licensed.
I guess I just want to make sure we cover all the areas that, if it includes monitoring and fire monitoring, it's more than what we're citing here, the installation and servicing of television or still cameras. It's that too. It sounds like it's that as well as monitoring. I just wouldn't want them to see this and try to just respond to that portion of it, or think that that's all they, because maybe they are just manufacturing and selling the camera equipment, but yet they're still monitoring. If they came back and said, they added some proof they weren't doing the installation of cameras, but yet there's still the issue of monitoring.
Right, I believe the monitoring issue is the main thing.
Okay, I don't have my red book, but is the monitoring included under this 6232-304J?
The language of that particular subsection does include monitoring.
It's just not listed in the legal report, but monitoring is covered under this statute.
That's correct.
Is the monitoring station that's actually doing the monitor, are they licensed in Tennessee to monitor in Tennessee?
No, it's the same company that manufactures that's also monitoring, and they're not licensed.
Licensed in any way for anything then?
I don't believe they're licensed in any state.
Okay.
Respondent states they are alarm servicing network that provides local contractors. And from my standpoint, our company has done that for outside people out of Georgia. But the person that's doing the install is licensed. That's kind of, I'm confused.
And I may have not explained it, but they do hire outside, like licensed contractors to install. But the monitoring, I guess maybe the recommendation, like over the 304, does include the monitoring, and it's not in here, and that's my fault. But it's the monitoring problem. That's the issue, is that they are monitoring their own systems through the retail stores. So if anything happens,
They're also selling them too.
well, they're selling them to those retail stores. I think it's exclusive to the retail stores and this company that owns many different types of retail stores. So they are selling their system, and they are monitoring, because if there's any problem, there is a sticker that says, call this company.
The only thing they're not directly doing is the install, but they're doing everything else that's involved in system monitoring except the actual install.
Yes.
My understanding is even if they sold it and had a licensed contractor installed it, if they're not licensed, they're still in violation. I think it's a gray area. Some people would argue if they sold it outside the state, to, like maybe the retailer's located in another state, and they actually made the sale in that state. I don't necessarily agree with that, but that's, like, some people make that argument, but even aside from that, with the monitoring, I guess, is the bigger issue. Amount on the number of, I mean, would we be better to do $7,000 based on the 7 years, or do we have or is the 5,000?
I think that's just first offense, the 5,000.
It's 5,000 per violation is the max.
Okay, I thought we were doing 1,000 per violation as an initial usually, but
I was just going off this exact investigation.
I was just trying to see where we were coming with that.
And that's the clarify, that is a way that you can assess the penalty if you want to do 1,000 for each year. I think, like Stuart said, he put the $5,000.
I'm okay with the penalty, but I think they need to know if they're going to be monitoring in the state, they need to get the monitoring license.
Well, you can include monitoring in the civil order, can't you? Or
Yes. Yes, we'll make sure that the consent order does,
consent order, I said civil order.
we'll
consent order.
have monitoring language.
Do we have a motion?
I'd make a motion that we concur with recommendations of council, but to also include references to monitoring at the.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Harvey to concur with council's recommendation with monitoring also included in the consent. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 2, 2018-076-191. Complainant, through an attorney, alleges that respondent continues to bill their client. However, no service has been provided to complainant. Complainant alleges harassment, fraud, and deceptive business practices. Respondent responded that complainant security company merged with respondent, and respondent continued as the surviving company and successor in interest. Respondent states that all contract agreements are valid and signed by complainant. Proof was submitted. Respondent interviewed representatives present at the time of the business sale of services and discussions about the equipment installation. The advocate found that complainant was present for the discussion of the installation plan, including the contract, its terms, and the payment method used for the account. Complainant even provided the credit card in her name for that contract. Additionally, it was found that when this dispute was originally brought to our attention by complainant, it was not about a question/allegation of the contract being invalid, but that complainant didn't want to pay for services received, and in fact, complainant was having issues with their tenant. Complainant wanted the tenant to pay for the services. Recommendation is to close.
Civil matter, I would make a motion we concur with council.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Richard to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Number 3, 2019-005241. Complainant was contacted by respondent from an office in Texas offering an alarm system to be installed. Respondent stated that they were licensed, gave the license number, and stated the installer was licensed as their employee. Later in the conversation, the representative stated the installer was an independent contractor that was licensed. The installer's name was not found to be licensed. Respondent responded that the caller was not affiliated with them, and the installer nor the caller were employees of respondent. Respondent also stated that they do not have an office in Texas that calls and sells alarms. Respondent is currently investigating this matter as fraudulent use of respondent's name and license. Recommendation is to close.
Is the respondent a manufacturer or an actual licensed installation company?
The respondent is the licensed company, security company. And it's believed that these people are calling and saying that they're with this company, however they're not. And they're just they're scamming people to get money, to pay for a service that is not through the actual licensed company.
We're running into that in our office. It's even showing up as another business, a local business. and then when you call it back, it's not that local business. I mean, these scammers are getting good. I'll make the motion to concur with council on this one.
Okay, we have a motion by Mr. Fraker. Do we have a second?
Second.
Second by Mr. Harvey to concur with council. All in favor, voice by saying aye. All opposed? The motion carries.
Number 4, 2018-088961. Complainant, age 93, was visited by two men representing a home security alarm company. The primary spokesman for the pair, a man who identified himself as respondent, said they were working in the area installing and/or upgrading alarm systems, and that they had just completed systems for a couple of complainant's neighbors, whom they named. Respondent said they had noticed from the sign in her yard that she had a security system from a company which complainant had for a few years. After much persuasion, complainant gave permission to change the system to the new provider of respondent. Respondent proceeded to change the system, which didn't appear to require any new hardware, over the next several hours. It was later discovered that the only change was the cell phone electronics portion of the existing system's control box, so it would dial their company's network in the event of alarm. Over the next 2 months, complainant continued to be billed by her old security company and received nothing from the new company of respondent. Complainant's son-in-law could no longer reach respondent, but did contact the other installer. This person stated that he no longer worked with respondent because he did not pay him and figured out he was scamming people. Later, it was discovered that respondent opened a credit card with the bank and charged the installation amount to this card to be paid at $45 per month by complainant. Complainant states that she did not sign any documents to open this account. The new monitoring company, which alleges it did not know of respondent, is working with complainant and the bank to cancel its service and return to previous company. They are also working on canceling the bank credit card account. Respondent has not been able to be contacted. Recommendation is referred to the local district attorney.
I saw up above that their application had been denied previously, too.
Yes, it had.
Make a motion that we agree with council's concur with council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Calcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye. Aye. All opposed? The motion passed.
The last one we have is represent. If you don't mind, I'll read off the number and then give you a few minutes to kind of read through, and then I'll read the updated information, if that's okay. Number 5 is 2017-060-071. go ahead and read the updated information. Respondent set up wireless cameras from Sam's and the self-monitoring app for his neighbor and charged him about $100. Although respondent added this service to his business card, there is no evidence that he continues to perform these tasks. Respondent's main business is pressure washing, laying asphalt, and some landscaping. All of respondent's posts on Facebook show its asphalt and pressure washing business. No posts have been made regarding installing cameras. It is believed the civil penalty does not match the severity of this matter or the possible public harm. The new recommendation is a letter of warning. And I'd also add that it would be a stern letter of warning and instruction.
We know if this is the only install that they have done, or?
The only evidence we have is
Just
it
this
was
one.
one installation for his neighbor.
Okay.
He had previously, when this first started, he was not doing just the doorbell. He was installing Sam's cameras for people, Samsung cameras for customers, and he was charging them for them. Isn't that correct?
It sounds like we may have been a little confused before. I know that's what it looked like to me originally, was that it was brought as though he put the doorbell camera in for the neighbor, and he also installed Samsung cameras from Sam's. But it sounds like in his response, he's saying all he did was install the Samsung camera from Sam's for the neighbor, that it wasn't a doorbell camera for the neighbor.
I don't think it was one incident, was it, Stuart? Wasn't it? He was advertising on Facebook, and he thought because there was no monitoring, because they were Samsung cameras, he did more than one install of these camera systems. I think the doorbell was a subsequent install that he admitted to. They were different incidents over time, correct?
The only evidence we have is the one installation that he went to Sam's, bought the cameras, and installed it for his neighbor. Then he thought, well, that's a pretty good business, and it's self-monitoring, so there shouldn't be a problem. So he put it on his business card, and I think he had it on a radio advertisement, and then that's when we got the complaint from an industry. It was an industry complaint. But the only evidence that I see is the one that he admitted that he helped with his neighbor. There is no other evidence that he's continued to install these cameras, and they're just the standard wireless cameras that you self-monitor on your phone. Everything that I've seen that he does, his main business is just pressure washing and asphalt paving. That's everything that he really advertises is about that business.
Assured us that he's going to remove all that advertising.
Only thing he's assured us is that he's not going to come to Nashville for anything. He doesn't feel like he's done anything wrong. I have contacted him a couple of times, told him to take it off, take the security camera off his business card, at least take it off Facebook. I have not heard anything. I'm continuing to keep encouraging him to do that, and will encourage him to do that, especially in my recommendation as a stern letter of warning and
Not
instructions.
done it yet?
It's still up there.
Okay, I didn't understand that. I thought that he had taken that off.
So let me ask the question, is that considered advertising? You did a business card? Okay. Stuart and I did talk about this a little bit. $1,000 is your minimum for unlicensed activity. We thought that was a little harsh. Did something wrong, perhaps. So you could actually look at the section about advertising, and then we're not stuck with that $1,000. It could be $100, $500, whatever you'd want to charge for that. If you feel like you need to discipline the gentleman. I mean, all Stuart has is proof that he did one install. him not bringing it down off the computer might be another, that's where I look at the advertising. That's-
That's a concern that he has not.
But you could move it over
responded.
from unlicensed activity, which is $1,000, to
I guess
something
it
else.
could be the wording that you've used in your summary. I don't get the opinion that he bought one system and installed it. It says installs self-monitoring Samsung security cameras from Sam's, and that he puts up self-monitoring. To me, this wasn't a one-time thing, the way it's worded. It's like he had this side business going, he was going to Sam's, and those do require wiring. They're not wireless. They may, depending on when he's doing it, a lot of their systems require wiring. So is he wiring these also? But I don't get the feeling. I think he had a deal going. He was going to Sam's, buying these box cameras, putting them up, charging somebody for it. He's advertising on Facebook. He's advertising on his business cards. So you've got two actual violations: the advertising and the installing security cameras.
And the fact that he doesn't feel like he's done anything wrong, and
Right.
that, and you did say in the summary that there's no evidence that he continues to perform these tasks. But if he's still advertising, that's evidence that he's continuing.
Well, I mean, the advertising, yes, can be a violation, and we can discipline him for not bringing down the picture of his card. The problem with you, when you have no evidence of any other installation or helping anybody else with their cameras or anything else, I mean, there's only certain things that we can prove and we can't prove. And if we don't
but
have
by
that,
his self-admission, he did it and got $100.
right, he was helping out a neighbor and got $100, but that opens up a lot, because what if I go in and help my neighbor out that could be disabled or something like that, and they need cameras, and I help them, and they give me a gift card or something like that in exchange? Well, now I'm susceptible to a $1,000 fine.
But the issue was, I mean, you're not going to add that to your business card if you do that either. You're not going to.
Depends on what kind of gift card I get. Right.
I don't so much have a problem with foregoing any of the fines if he would just, once he learned he was in violation, that he would cooperate and take the advertisement down. If there were a way to assess a penalty that would go away if he would comply, I don't know. The fact that he did not do that immediately when he found out he was in violation of a code is the part that bothers me, I think.
I make a motion to continue with the previous recommendation of council of the $1,000 civil penalty for unlicensed activity.
Second.
We have a motion by Mr. Cockcroft and a second by Mr. Richard to stay with the original board decision, which was consent order to respondent with a $1,000 civil penalty for violation of TCA 6232-304. All in favor, voice by saying aye.
Aye.
All opposed?
Nay.
Breaker? No. Aye. Or
Aye. Sorry.
Okay, the motion carries. Four, and Mr. Harvey voted nay.
Okay, so what we're saying is, we're staying with $1,000, so Scott, I'm sorry. Stuart, and go ahead with the formal hearing.
Right.
That's where we're going.
Yep, we'll get on that. That concludes the legal report.
Okay, are any of our I was going
Yes,
to
there
say.
are, but could we take just a real quick
Certainly.
break? I got something else going on, and I'd like to address that. Sorry.
We're going to recess for about 15 minutes. Will that be enough, Cody?
Yes, that's fine.
Okay.
I think that'd be plenty.
Ms. Vest?
Yes. Mr. Pollock? if you go ahead and look on your iPad, this gentleman asked to appear. He was asking about a rule 0090-06-.04, contracting with customers. Did you sign in?
Yes, I did.
Okay, good.
So I'd like to make a comment here for transparency. Roy works for Comcast. He is my director, so I report to Roy. So I'm going to remain silent and not commenting on any yes.
Well, if it's okay, sir,
Is
I
it
want to ask you to come over here because there's a mic. We want to make sure we capture everything. That's all right. There you go. Then you can have a mic.
Thank you.
Thank you. Well, if you would, give them a few minutes because they have not seen what's on their iPads and the reason for your...
I don't, do we,
Oh, that's there.
we don't,
And give them the...
It's just the email.
Well, that's all you got, it's an email.
Oh, okay.
He's asking to appear to discuss what I just read out
oh, okay.
for contracting with customers.
We've read it. Go ahead, sir.
Okay.
Good morning, ladies and gentlemen. Thank you for allowing me the opportunity to speak to you this morning. My comments are solely my own as a Tennessee license holder and as a Tennessee-approved CE sponsor and trainer. They don't reflect any organization or my employer at all. About 2 years ago, or about a year and a half ago, I attended a seminar at the annual Tennessee Alarm Association event, in which time a presentation was made by representatives of the state, and this is one of the slides that was shown during that presentation. And the last bullet, number 3, talks about alarm contractors shall train their employee registrants with respect to the terms and conditions of a contract so a customer's questions can be adequately answered at or prior to signing the contract. And this comes out of your rule 0090-06-.04, item number 3. The issue is our contracts, any contracts from any alarm company, are prepared by legal counsel. There are a lot of different terms and phrases and issues that are in the contract which are very complex, and our employees, whether it's any company at all, doesn't necessarily mean my employer, but anywhere around the industry, is much too complex for them to be explaining to prospective customers. The right of rescission 3-day federal cooling off period allows that person who is signing that contract time to read the contract or have their attorneys review the contract, and if they so desire at that time, to cancel the contract. Having our employees interpret the terms and conditions of a contract could eventually land in a court of law with a claim that the interpretation overruled the written word of the contract, and our employees are not legal aficionados, and they are not trained in the complex conditions such as the exculpatory clauses, limitation of liability, hold harmless clauses, and so on. I would ask that the board reconsider and revisit this issue on having untrained and unqualified people trying to interpret what has been prepared by legal counsel under the regular rules and laws of the state, whether it's this state or any other state. And we stand by the contract. We do not let our employees interpret what is written there. We ask them to go get their counsel, have it read by them, and we give them the 3 days to cancel, which is the federal ruling anywhere in the country.
Let me see if I understand what you're saying. You're just... I was going to use a word. Let me find another. The rule that, I believe that was several years ago. I mean, some of the board members probably remember this was a long discussion. It came about because people were signing these contracts and coming back to us and or back to the board and going, well, that's not what the salesman told me. So that's how it all started, them trying to explain it to our new board members.
And that is the point, that there could be a claim in a courtroom that somebody has overruled or superseded the written word of the contract based on the explanation. There was just a recent litigation with ADT and a customer's estate where a woman had died in a fire, and this is just about 3 months ago, where they brought a claim against the alarm company based on failure to respond to the alarm signal, and the judge in that case handed down somewhat of about a 15-page ruling just explaining the defendant's contract and the conditions that were in there, such as the hold harmless clause, the exculpatory clause, and their limitation of liability, as well as others regarding signal transport and reception of the signals. If a judge has to take 15 pages to explain that, how is a non-trained alarm technician supposed to interpret what a legal mind has written down on that piece of paper for signature by a customer? They didn't go to law school. They didn't go to years of college to get this education. It's very hard for somebody to be explaining what they don't understand.
I don't disagree with you on some of it. I got in on the rules had already been made up, but they were going through the process when I was appointed to the board. Some of the intent of it was not that they be legal experts, but that explain very general terms. The other side of it is it does say at or prior to. I mean, they're not forced to sign the contract that day. You can always have your legal counsel get involved with them if the customer has a question about it. If you tell your employees, well, they can't explain it, all you have to do is provide someone that can. So if they've got to go, get an attorney, or they can consult your attorney, that can meet that part of the statute or the rule. But the intent was to explain the very general terms of the agreement. If someone just puts an agreement forth and they can't explain anything about it, that it's like, well, this is what you're paying, and it is for 3 years, or it's for 5 years, or that was the intent of it. It's much broad. It sounds much broader than that. That was the intent. And me personally, the way I deal with it in my company is that, if someone had an issue, they have plenty of time. They don't have to sign it right then. That's your issue is if they make the choice to go ahead and sign it, but you could still have your attorney, talk to them. And I don't know how else you deal with it at the, currently at the moment, but.
Well, it would be kind of the fox watching the hen house if I had my attorney explain my contract. That's one-sided. They should be engaging their own attorney, their own counsel, to review it and give an opinion on how it affects them. My attorney might be giving the information on how it will affect me and our company. The consumer has that 3-day right of rescission, so if they do sign it, they still have 3 days to cancel an agreement, which gives them time to contact an attorney and say, hey, can you look this over? But to have someone who's not trained, who's trained in alarm installations to try and explain a contract, I think is a little bit over the top and too broad.
So the people that would present the contract to the consumer is the same people that does the installations on the systems?
It could be the same person, it could be the salesperson, it could be an installer. It depends on how the company operates. Some companies do telemarketing, so they'll send somebody out to do the installation with the contract at that time. Others will send a salesperson, have it signed, and say, all right, we'll install the alarm next Tuesday.
Do your employees receive any training whatsoever as to the content of the contracts?
I'd rather not speak about my company or any other company.
I'm asking, do you offer training on contracts to your employees?
We do not. We advise them not to interpret the contract and to advise them to have counsel review it if they so desire.
So you're saying that they go with a contract to a consumer's residence, that they have no clue what it says or what it means?
They have a clue about as much as the consumer probably does. And I don't think that I could explain the exculpatory clause or the limitation of liability clauses as well as this gentleman sitting right here who is your counsel. These are very complex issues, and as I mentioned, these are decisions that have come down in long, multi-page decisions in courtrooms on interpretation by a judge, rendering a decision one way or another.
Have you reviewed other companies' contracts?
Yeah, I'm very familiar with many contracts.
Okay, how do yours compare with others? Are other consumer or other companies' contracts as in-depth legally as yours are?
I believe they are.
I'm not in the industry. Let me explain that. I don't
Okay.
know. I'm asking, as a consumer, is your contract more complex than what his company's contract might be?
I don't think so. They have the same standard clauses in there, general clauses that are in there. They may be worded slightly differently, but the overall conditions are probably very, very similar.
Okay, I'm going to ask you this. You keep referring back to the 3-day federal law that allows you to back out of a contract. If my alarm system is installed on Friday and I can't see an attorney until next Thursday, what happens?
That becomes 4 days. Saturdays and Sundays are not counted, 3 business days.
But what if I can't see an attorney until then? Am I still locked into your contract? I want to see an attorney. I want to make sure that I understand and I agree with everything. Are you going to let me out of my contract if there's something?
That's a company decision, and everybody handles it differently.
I think there's too much reliance on the federal 3-day contract to satisfy me.
When you get the contract signed, do you explain the 3-day?
Yes, it's given to them.
That's one of the terms we'd like them to explain. I mean, that's explaining some terms of the contract.
Well, they explain that you have 3 days to cancel the agreement, and it's acknowledged by them. They sign that they've received it, and then there's a second line that says, I hereby rescind the contract. Okay, so you have an acknowledgement that they've received that, and the wording in that, it comes out of the federal statute. The wording is in the federal statute on what has to say.
I understand, but those are some of the general terms that we expect from that rule, that we expect your employee to be able to explain to them. How much they're paying a month, how long is it for? I mean, so general terms, not necessarily all the legal mumbo jumbo, but the intent is that you're not, you don't send an employee out and stick a contract under their nose and not tell them it's for 3 years, or not tell them that it's, it goes up in 6 months, or, that you tell them the general terms of what they're paying and what they're doing. I guess you could always have, you could have some other document drafted that said that if you don't want your employees to explain it. But that's what it was intended for. Those rules also went out, and there was a long process. You didn't show up. I think we had one person that showed up that after everything went out. It was Howard, and I think he actually was for that particular thing. I tried to argue against that particular rule, but there was a long process that you were free to come. And then there was even a process after that. I believe there was a period of time, either 12 months or something, that it can be opposed. And none of that happened. But it's not meant to be onerous. It's not meant to make you have to hire attorneys to go with every installer. The intent is that we do have a lot of complaints where customers come forth saying that they weren't told that it was a term contract, or they weren't told a lot of stuff. And we're looking for the basics. We'd like them to be able to explain the fill-in-the-blank part of the contract. That's really what we're asking for.
We have our employees tell them it's a 3-year contract, you have 3 days right of rescission, but to get more in depth with, well, what does this paragraph about limitation of liability mean? And having a technician say, oh, well, that just means if something happens, you're limited to $250, or there's a lot of differences that can be inferred by somebody making a representation of what that term or what that paragraph means. Now, if you're saying that that is not the intent, and that is simply explain the terms of the contract, such as a 3-year contract, and you have 3 days. If you don't do it in the 4th day, then you're stuck with that contract for 2 years, 3 years, 5 years. Some have a 10-year. Some have a 10-year agreement. Excuse me. Then that's fine. But I'm more concerned about getting into the weeds with every one of the other paragraphs that this appears to refer to, of explaining everything in that contract.
And if you take it that far, all I know to say is, get your attorney involved with them. Let the attorney, and I understand what you're saying, you don't think your attorney should have to explain some of it, but I don't think it's necessarily unreasonable if an end user wants to know kind of what the limitation of liability is, to have an attorney explain that to some extent. But that's your company. You're right, and you say you're not here on behalf of your company, but
I do training. I have courses approved through the Tennessee board, through you individuals here. And if I was to do a training class tomorrow on the rules of Tennessee, I've got to include this and tell them you need to become, junior Philadelphia lawyers and understand what all those terms and conditions of your contract means.
What form of action would you like to see happen here? What do you think would make it better?
Either a revision to, as Mr. Cockcroft has stated, what it should be outlined and what should be explained, or some other revision to this. I understand the intent of individual not getting, I got to change the word I was going to use, not getting hurt by signing an agreement that is onerous. But on the same point, I don't want to be before this gentleman here 6 months from now that I have a complaint from a consumer that says I didn't explain based on paragraph number 3.
But of the hundreds of millions of alarm contracts that's out there that's probably not been explained to customers, how often is this a problem that we run into?
Just as I didn't understand it until it was presented at this seminar, I don't think a lot of people understand it or know that it even exists, and especially those that did not attend the seminar probably have no idea that this exists, and they don't explain the agreement. Oh, don't worry about it, it's just a standard form, sign here, and move on.
What would you suggest then on the wording? Because like we've told you, this rule was written because of the deceptions in the contracts. Especially, we can't look at just one segment of society. We have to look at all ages and all intelligence. And we had people that were not told in their contract that after so long, their monitoring rate was going through the roof, or the system, they did not, it was the basics of it. Now, I know we live in a legal world where there's arbitration, mediation, and all that attached to everything, basically, in a contract that we sign now, but you want it to say we have to make them tell them the terms of the contract as it pertains to install, monthly fee, and the length of the contract, but exclude legal? I mean, tell us how you want it worded, because it's not going to go away.
I think that you've hit the nail on the head. You could expand on this paragraph and say, to include, for example, term of the contract, how to cancel a contract if you wish, what the 3-day right of rescission is, at least those primary things, but to stay away from the other legal terms that are in that agreement, because those are very complex paragraphs that, again, beyond my expertise to explain, and I have done this for 45 years, and I've dealt with it, and I serve as an expert witness in our industry, and still shy away from trying to explain those terms. Those are for lawyers to explain.
What the statute or the rule says is, it says so that a customer's questions can be adequately answered at or prior to signing. It's their questions. So if you've got a certain, range of questions that you're comfortable with your techs answering, fine, they can answer those and move forward. If there's questions you're not comfortable with your techs answering, train your techs, say if they ask these questions, refer them to somebody else, or you refer them at that point to the attorney. But it's just at or prior to signing. Don't have the consumer sign it if they've got unanswered questions. That's what this is relating to. Don't say, oh, well, I'll find out for you, or I'll get somebody to respond. Don't have your tech go on and say, oh, well, just sign here and don't worry about it. That's what it's saying. It doesn't say you have to go by paragraph and explain it, even if they don't ask the question. It says if they ask a question, that you've got to be able to adequately answer it prior to or at signing. So prior to, if they aren't comfortable, just, they refer it to somebody else. But I don't think it needs to be changed the way it's currently written. It does say it's answering their questions. If they don't ask a question about limitation of liability, then you're good. I do think you should still explain some other general terms, but that's a personal decision on your part and a company decision on your part. But the way I do it in my business is that, if someone's asking a question beyond what I'm comfortable with my techs answering, they don't move forward with having the customer sign it. I think the way it's written is adequate if you handle it like that.
Would that be something that would be agreeable with you?
Well, I think we do that now, but I'm looking at the very, the words that are written as in the rule. If ma'am, you said you're not in the industry, and if you ask me a question then on what does this exculpatory clause mean?
It comes with training your employees to say that's beyond the scope of my training. You need to consult with either your attorney or here's a phone number to call at company ABC.
Our techs are
Then it's
told to
covered.
tell the customer to consult their attorney. We don't allow them to explain what those, they do.
That's what I'm saying. It goes beyond the scope of my training. Your choices are consult with your attorney or here's a 1-800 number to call our company to explain.
So
and
you-
then the tech is out of it and the customer has two resources, their attorney or someone in your company that could help them.
So if I understand you correctly, I'm just going to rephrase or restate, if they're asked a question about the exculpatory clause, limitation, or any other paragraph that the technician is not comfortable answering, and he says, you should consult your attorney to review this agreement, that would constitute being adequately answered under this paragraph.
I would think so. Do y'all agree?
I
Okay.
understand what he's saying is it does say you shall train your employee with respect to the terms and conditions. It does say that the employee is able to. I think that's what's probably a little onerous on the alarm company. It's saying that employee has to be able to answer all their questions. I agree with you. I don't think that that's necessarily practical. So maybe some wording could be changed from that standpoint. Now, I don't know what we have to do to change rules.
No different than buying a cell phone. That 16-year-old in the cell phone store don't understand all those rules and regulations on those.
But we don't have a state rule that says they have to be able to explain it to them.
Yeah.
In this case, we've put forth that rule.
And the difference between that is you're in the store and not in my home, therefore the 3-day right of rescission doesn't even apply.
Roy, can I ask you, are you asking for your company or as a teacher that you're going to?
I'm asking as an individual license holder in the state appearing before this board.
Okay, so their discussion that what they're having, is that going to fall over into what you're teaching?
Yes, because you have to decide how to deliver this rule in a classroom, and somebody asks the questions that I'm asking right now, how are they supposed, don't worry about what the contract says, just explain it to them and you'll be okay. That's not,
I don't think that's what we're saying here. I don't think
No,
that's what I
right.
understand what you're saying. I just wanted to
We're
clarify
saying
what
that
we're
there's
talking about.
basic things that a technician should be able to explain to a customer, whether it's the salesperson or the installer. There's basic things on a contract that they could read to them. But then if it's something that goes beyond the scope and training of their job, say, I'm sorry, you need to consult with your attorney. And if you don't feel comfortable signing this, okay. Am I right? Do y'all
Oh, I agree with you. I think that's what should happen, but that's not what this rule says, is the problem. This rule,
No, it says that they can adequately answer at or prior to signing. So it's not locked in about they have to do it, and they've answered the question.
Well, I mean,
you need to consult with an attorney.
I'm saying from the standpoint of if we're saying that it's okay to say, well, you should consult with your own attorney, then that's not training any employee to respond to their question. Which I think that's okay in my mind. I think that's what we should be aiming at but that's not what this rule says. The rule says that alarm contractors shall train their employee registrants with respect to terms and conditions of the contract. It doesn't say or refer them to their own attorney or.
But it says adequately answered, and to me, to tell somebody that's an adequate answer.
You think just saying you should consult your own attorney is an adequate answer?
I do.
Personally, I think it should probably read with respect to the basic terms.
But that's
define basic.
Yeah, that's
I know.
What's basic? Does that
What's
include
basic?
cancellation? Does that include, automatic renewal? There's a lot of things involved with that.
So you asked me how to
And so who
reword
are
it.
to tell a company?
I would consider that you adding, a colon at the end of that and list A, B, C. Length of the agreement, cancellation, other things that you might consider pertinent without going into the weeds on the legal paragraphs, and then at the bottom say, for all other matters, advise customer to consult their attorney.
But who are we to set what a company is limited on making their employees do?
But you are here.
Kind of left it wide
Yeah.
open in here. We've not limited it to anything. But
No,
if I'm a company and the state tells me, well, you gotta have your people trained in A, B, and C on a contract, I should be doing that already as a responsible company anyway.
Not saying that they don't, but reading the wording here, somebody can get a complaint, and I heard about a bait and switch complaint this morning that was done, and somebody can say, well, they did not adequately explain that I was going from A to B, and I didn't understand what the 250 meant, and I didn't understand that I had to have my own insurance, and that you weren't protecting me that way. There's a whole lot of different phrases in that contract that our technicians just are not capable of answering, and this gentleman is going to call my technician to the stand and say, where's your law degree? How did you interpret that? Why did you tell the customer it doesn't matter? Or this is just, a formality. I don't think anybody wants to be in that position of sitting before the board, or not even before the board, but sitting in a courtroom and trying to defend their agreement when you violated one of the rules of the board.
Well, actually, I think I'm pretty simple when it comes to this, say, contracts. If I'm a if I'm a business owner like we are, all of you are, okay, you probably already know the simple questions consumers are asking. You already know when I go into this house, they're going to ask me how long is this contract. They're going to ask me how much is my monitoring. Who do I call when it breaks down? They're going to ask A, B, C, D, whatever, how many. It sounds pretty simple to me. You just put those, the majority of the main questions a consumer asks on a piece of paper, and that's what you train your people to do, and the questions to answer.
I think most every
Company already
does that. What we're kind of worried about here, what you're not probably as concerned about on that, or as far as having terms explained, are the really legal intricacies of an alarm contract as far as limitations of liability, and things as far as like subcontracting monitoring to a central station and different stuff that most.
Well, what consumer would know that?
They're not, but this statute says, or not, I keep saying statute, but it's a rule, but this rule says that installer's got to be able to explain it, and that's the concern, is that an installer shouldn't really be explaining some of the legal ramifications of a limitation of liability.
But I think the board planned for that in the phrasing of at or prior to signing the contract. So if they get to a point where they don't understand the contract, you should never be signing a contract that both parties don't understand anyway. And so I think the at or prior to signing the contract puts in the caveat for both the consumer and the business owner. Okay, we don't understand this term. Let's get our lawyers involved.
I agree with you.
I think Mr. Pollock's problem with it, and mine as well, is where it's saying to train their employee with respect to answering the terms and conditions. I agree. I mean, I want the customer to be on board with signing. You know, when they sign, they know what they're agreeing to. I don't think that a technician in the field who may be a lot better at installing an alarm than a lawyer is also not as good as a lawyer at explaining some of those terms.
So for that installer, is the training not to say, I'm not trained in that? The person that's trained to explain the terms and conditions is X, and then you contact that person.
This doesn't say that. This is they have to be trained with respect to answer the questions. If you could say with respect to the terms and conditions or refer them to others, or there needed to be some other wording in there. But what are our options? Can we make some kind of a...
At this point, there's currently an executive order freezing any rules, so we couldn't change anything right now anyway.
Mr. Pollock have any means to oppose something or whatever at this point or anything? Or?
No, these rules are already effective. They can't. They would have to go through the rule process, and like I said, that's
So
already.
you weren't aware of
been
this
frozen.
rule when it was in the pending
No, ma'am.
process?
And I'm on your email list. I get your newsletters, and I have many state licenses, and I keep up with all newsletters around the state. And I think I broached this issue during the seminar, and was told the same thing. Oh, well, this was, had opportunity to go there, but I did not know. And I travel all across the country. It's not a matter of not having a flight to get here or anything else. Had I known, it would have been here.
Is there anything that we can do to make some sort of a ruling or something to further clarify this rule, or there's really nothing we can do?
No, sir, this is a rule. Any changes to any verbiage on this would have to go through a rulemaking hearing. And yes, we do have notify. I tell everybody, please, and when you're out there teaching, Roy, they need to know to go to notify. Is it notify.tn.gov? Sign up for the emails to make sure, because these are automatically shot out to everybody when we have rulemaking hearings or any changes. And when we have a rulemaking hearing, I'm required by law to notify different steps. There's different steps I have to take in different places. I have to put that notified. And Roy's right, we did talk about it at that seminar.
It was already approved at that point. It was already...
No, we send them out in advance of this rulemaking.
No, I
hearing.
agree. I'm saying with what he's talking about.
Oh, when he brought up that, yes, okay, yes.
But yes, there were numerous notifications sent out.
Opportunity, yes,
Because
sir.
I saw them, aside from being on the board, I had seen the notification. I got the emails, and I think there was even was there not a mail out as well?
Oh, yes, there's always yes, sir, I have to do a mail out, I have to do the,
There
they're
was a
trying
lot
to
of
change from
notification.
the actual paper mail out to everybody getting it by email.
And I don't know if this would be workable for you or not, but when we say, with respect to the terms and contracts, or the terms and conditions of the contract, if I'm the installer and you ask me a question that goes outside, it goes into the legal realm, and I tell you, I'm not trained in that area, but here's your option. I've answered your question. You should be smart enough to go, okay, I don't feel comfortable signing this, or I need to talk to somebody. I've answered this, but I've not gotten into an area that I'm not trained as an attorney. Instead of saying, I don't have a clue what that means, or I just sign it anyway, say, this is a section that I'm not well versed in. You need to consult with your attorney, but you also don't have to sign this contract until you feel comfortable. I think there's a way that you can train your employees that's going to be satisfactory to everybody without a rule change.
I think that most employees from most companies are trained to do the basics. How long is the contract? How do you cancel? What's my monitoring rate? Who's my monitoring company, if they either do it in-house or subcontract? And beyond that, if somebody asks a question, they say, well, we suggest you contact your own attorney to review this. If you're saying that is meeting the adequately answered, then I'm fine.
But if there's an area of that contract that I, as an installer, it goes into the legal field, I don't give you my interpretation of what it means because I'm not qualified, but I tell you, you need to consult with an attorney on this. I've answered your question.
And
I've
that's
not
fine.
gone, oh, don't be stupid, sign this, or whatever. You know, you can train your employees that if you go past this section of your company's contract, anything below here, you're not trained to answer. They need to be referred to A, B, or C. The end. Don't give your interpretation.
So in my class, if I list the rule and explain, you should explain those basic 4, 5, 6 items, and then say if they ask you a question about any legal issues, to consult their own attorney.
Or
you would-
anything they don't feel comfortable
or
with.
anything they
you
don't feel
have a
comfortable,
right.
then that meets the intent of the rule, and you're satisfied with that.
That was our intent of the rule.
Okay.
Because we've had a problem with companies coming out and offering a person a second contract when they're already under contract to someone else. And it ends up being a consumer affairs issue. But I would hope somebody that when they want my signature and I ask them basic questions about service, length, what it covers, so on and so forth, I would hope the installer could do that, but I, as a consumer, would not expect an installer to be able to give me a full explanation on some of the other terms and conditions legal terms and conditions you've got in that contract. And it's a shame we've reached a society that's got contracts that, exceed most books, but that's it. And requires
And
a
if the
legal
board is,
degree
if the board is agreeable on that and they consider that to be the answer,
That's
then
my
that's,
opinion. I want to hear from the
then
others.
that's how I'll include it in their training,
But
and
I've
that'd be
answered
fine.
your question. I'm not a lawyer. You need to talk to a lawyer.
Okay, so please understand, you're not making the decision of the board, you're
No.
giving your personal opinions.
All right, that's the problem, is that if
Because
something happens
he's gonna
10
go
years
back
from
and
now, and we're not
say-
here.
May I make a suggestion here?
Yes.
Why don't, before we turn this into something big, why don't we table this, give us an opportunity to discuss this amongst ourselves and with council and come up with a suitable answer that we would offer as a board decision to hopefully give some closure to that question. Would that be acceptable?
I don't know when we would do that. We could set it for another meeting or something, but whatever discussion would have to be.
Right.
Let's,
But we can't, you said it's closed, we can't make a change
you cannot
until,
make a change.
when does that become that we could make a change?
If that's the decision the board would come to, it would have to be after the governor lifts the freeze. There's currently a 90-day regulatory freeze on any rule. That does not stop your discussion. If there's a decision that the board wants to make as far as interpreting that rule, I guess you could do that in
We could put
in
forth an
open
opinion
meeting.
or something, or a.
But an
Maybe,
unfinished business,
but
maybe.
the opinion, you don't want to further restrict the rule in any way. Because if you put forth an opinion that further restricts the rule, then it's starting to become overly regulated. And we don't want to get into that area either.
I think we would be making it broader. The concern, my concern with the rule, we can say that, what I know its intent was that if someone does mislead a customer, that we have a way to hold that alarm contractor or unlicensed person accountable. Right now, we don't have anything. All we can say was that's a civil matter. And we can't do anything to the person that did something unscrupulous, that didn't tell them it was a 10-year contract, and they told them, oh, yeah, you can cancel anytime and everything. But the concern is, on the other side, that when we're not involved whatsoever, but someone goes to court over an issue that's a liability issue, and the consumer says, well, that wasn't explained to me in detail, and, I think they should, pay for replacing my house because it burnt down. If we have something, that says they have to explain it, and I think that's where you're going. That's your concern, is if our rule is brought in somewhere else in a court of law or something. And I don't know if us interpreting what we're looking for changes that either, but is that somewhat of your concern? That
Civil liability is a concern, as well as, licensing liability coming before the board for doing something that was outside the scope of the rules or the statutes. And, my company tries to do everything we can. We have a staff that goes through every rule in every state. But again, I'm not speaking for my company, speaking as an individual license holder concerned about this, and as an instructor to properly train individuals.
What are the other opinions of the board? I mean, what do y'all feel?
And I did not expect a decision today, so
I think it's a serious matter that we need to spend some time discussing, and maybe some devoted time just to it, rather than to just throw out.
Okay, so I think we all know we're not going to be able to do anything to the rule till we hear from the governor to begin with, or even if we do want to change it. We'd like to thank Roy for him coming today and bringing this matter to our attention. I believe you're right. We should put this on the agenda. We should allow adequate time for the board. But then, are you actually just going to give your opinion out of the board opinion, because you're not going to be able to change the rule unless you would go to a rulemaking hearing?
That's what I was going to say. If it's something after you all have discussed it that you think needs to be changed, it would have to be after the freeze is lifted, and then we could begin a rulemaking process if we need to change the language of the rule. Going to Keith's point, it may be something that we need to further discuss to decide if it is something that we need to change and how to even change it. Because we don't want to take away the responsibility of the alarm companies of training their employees when they are trying to enter into contracts with consumers, because we are charged with protecting the consumers. But if it's something that is causing confusion for the public, not necessarily, well, the companies as well, but more so for the public, if it is causing that confusion, if there is an unattainable responsibility on those companies, that is something that we have to look at. So I don't think there's anything we can do to the rule without the freeze being lifted at this point.
It's just 2 meetings from now.
Right.
thank you for your time. I didn't mean to take up as much of time as I did, but thank you for entertaining it.
Thanks for coming.
Thank you, sir.
And you, Roy, you might want to be here when they have this discussion. Oh, I will be. It'll be on the agenda. I believe, Madam Chair, we would go probably into my segment now of administrative matters, if we may.
Okay, we don't have any more appearances.
Right, we'll just go, I tell you this every month. It's a monthly report. We'll just scan right through, jump right through this. So I had talked to earlier. I do have the paperwork for Scott Coffcroft and for Keith Harvey for the real. I've not got the official notification. I will let all board members know. To see the has all my other programs there that we do meet. The attorney meets. We discuss the budget, and we discuss other items as well. If there's no questions, which there usually isn't on that segment, we'll just move right on to the budget review. Okay. You have, for the month of December, you were in a negative $2,786. Overall, though, the ending budget total should be $63,060. Month of November was a regular, if you go up there and look at other for 35,308, just to bring it to your attention, as the 30,000, do you see it up there? And for November, under alarm expenses, it says other, and it's $35,308, I believe. 30,000 of that went to PSI. because all the contracts had to be rewritten for the exams. You have 4 exams. Okay, and we did that earlier in the year, but that's whenever it hit the budget, 30,000 of that. That's why you were in a negative, helped with the negative $10,498. Well, we didn't exactly pull out the next month for December. Excuse me, you can see revenue was down. Revenue was down actually in November and in December. We do expect to pull out of that. In total is $63,060 to the good.
There's that 63,000. I'm
And
trying.
if you can see it on there, I'm going to ask them to change their color. It's orange or greeny looking.
It's
Yeah,
that
I
block.
think if you took the $306,395 and subtract $243,335, you should get $63,060. Yes, I'm going to ask them see if they can adjust those colors because it doesn't copy over very well. It's hard to read those numbers. Legislative update? I didn't have any legislative update. Do we have an extension? Yes, we do have a couple of extension requests. As you know, the statute says they can request an extension. They have if I could do this by memory, 10 days to notify me, then they have 30 days to replace the qualifying. It ends up, they got a good 6 months. They come in and ask for an extension, I grant the first extension. We do understand there's certain circumstances and they need, perhaps they failed the exam or whatever. But anything after that first extension must come before the board. That's what you have told me, so this is what. This first one here is TNT Security Incorporated. They're asking for a second extension to replace their qualifying agent. His exam is not scheduled till, tomorrow, I believe it is. He did not pass the exam the first time, so he is rescheduling. It is tomorrow, so they had to ask for an extension.
Owner, there was a prior qualifying agent?
Yes, so there was a different qualifying agent, and he did not qualify the license. One left. They tried to get another one, but he did not qualify. And this is Michael Renfro. But he did not pass the test either. So he's had to read.
That 1866, their company number?
Yes, ma'am.
Okay. So what do we normally do? Give them 30 days on the extension on this? 90 days?
They could, if the things didn't work out, they'd come back again and ask for a third extension.
I'd make a motion we grant the additional 90-day extension.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to grant this request for extension for a QA. All in favor, voice by saying aye.
Aye.
All opposed? The extension is granted.
All right, if you take a look at your next one is for Karen Jones. Excuse me. Is asking for an extension to replace the qualifying agent. If she's not able to find one, she said she's going to try to requalify it again herself.
She's been an QA? Is that,
She was a board member as well. She actually is a QA.
She is a QA. She's saying she's trying to sell the business, so she's just looking for an extension. She's saying that if she didn't sell it, she would then go ahead and renew her qualifying agent. And her father,
Trying to get out of the business.
and I believe it's her father, and I don't
Okay.
know if he had been sick or passed away.
There's been several things that have gone on. Ms. Jones also has an alarm company, and she has a locksmith company. Did not, as of yet, renew her qualifying agent. So this is just a little bit odd, in my opinion. She didn't renew it yet, so I did explain to her the length of time that she has to renew in several emails. She has a sell her company for whatever reason. Goes into, what do you call it when you expire? Yes. If she goes into a grace period, I explained to her she was not to work. We all know that. You have to renew your license. I believe asking for something I could not grant her. You either renew your license, you go into a grace period of 3 months, and then you expire, you will need to reapply. So there's several things that's going on with this. To replace her qualifying agent, yes, she will have to do that if she does not renew.
Why would she not
So she's-
renew? Is it
Because she's trying to sell her company.
But even at that, I mean,
Let's get your CEUs.
And she says she has the CEUs,
She has the CEUs, so now it's just a matter of the,
the cost.
Well,
$100, $200
exactly,
bucks?
maybe not.
she don't have the CEUs. Okay.
Well, she probably could get them by the time that she needs to do this. It's just awkward. When she says, I want an extension to replace my qualifying agent, that's not what she's asking. She is the qualifying agent. Now, if she's going to let her license lapse and go get a qualifying agent, I'm going to say, okay, you've got X number of days to replace a qualifying agent. That's the way the policy reads. And then if she needs an extension, I will grant that extension if the individual could not qualify the license in that length of time. If she comes back and wants a second extension, she'll have to request a board. But what she's asking here is for you to give her an extension on her license.
Oh, you can extend the expiration date.
No, we cannot extend. I've explained this on numerous occasions to Ms. Jones. I cannot extend that expiration date.
The
It's
board
set.
can't do that. That's set by
No.
statute.
Can you look that up for me?
The board can
I didn't
extend
put
the
it down on that
expiration
thing.
And she is asking she's not asking to extend her license or anything. She does say her QA replacement. I mean, she's asking for,
She is the QA.
I realize that, but she could
She could replace it. She could decide to get another, she could decide to hire another individual that's already a qualifying agent for her company, or she can submit one who would need to take the exam and do all the paperwork.
And I do think there's extenuating circumstances there with her father's illness.
There are
and-
no extenuating circumstances, Scott, when it comes to her expiration date. That is set by law. I don't mean to sound harsh about it.
You're right.
I don't understand.
When does her license, so her QA license expires when? It was November?
It was in November the 30th.
But when did she,
At the end of this month.
See, she's out of grace at the end of this month. Today's what, the 21st?
Yeah.
I have explained to Ms. Jones I could not do that. Several of us have explained that to Ms. Jones, that we can't help her here. But she requested to come, for me to present this to the board, and that's what I'm doing. Are you asking me if you have the authority to do that? I'm going to tell you, no, you do not, according to the statute.
Yeah.
I have brought the paperwork before you. I will give her a formal opinion.
are there
For the
any
board,
other, are there
if you
other,
tell me.
is there not another employee or someone else at the company?
No,
There's no other employees?
there's nobody else there. I do know there are extenuating, what you say, extenuating circumstances. She has been at the hospital with her family, and there's certain things that have gone on and all that kind. I do understand that. But if you had your CEUs, all you have to do is give me a picture and money. That's all you really had to do. And that has been explained as well. So that's just I'm just bringing it to the board like someone had asked me to do the request. But I do think I'm going to have to go back and say, no, the board said, the statute says, and this is what we'll have to adhere to.
I've sat here for a long time, many, many years. I've seen a lot of these crazy cases come across. I have seen us do some very unusual things in special circumstances in the past that we would not do for everyone.
No, I don't think.
Well, maybe not that we wouldn't do for everyone.
Okay.
That circumstances made us be creative at times. Do you feel that in her case, that what it really boils down to is maybe possibly a financial situation, that she's not able to afford to renew the license, or is there other things that would prevent her from just renewing her license at this time?
I am aware of Miss Jones' situation. Again, all she had to do was give me a picture and money to pay for her license. If she lets it expire, she's going to have a very big bill, as you know. She'll have to, what all she'll have to do. Her financial situation, I cannot take that in consideration. The statute says, now if she wins the lottery, bars me, I don't know what the circumstances. I don't exactly know what you're asking me either. When you say, is there something that we can help her with?
Well, it does seem like we've granted a lot of extensions. There's been times
You
when
have not granted this extension. This is a person's license.
Okay.
By law, by statute, it
Granted
says.
extensions when a company cannot find a QA or.
and I've used the
not
wrong word
Her
when I said
problem with
extension.
Testing
But
dates.
she's not asking for a
She's not
company
asking for
extension.
that.
I agree,
Yeah.
but when.
You just take the one that talks the
We're
loudest.
passionate.
That's what Jenny does.
I agree with Scott that there have been times when we have granted extension.
For what it's worth, I would say that Miss Jones has been a respected person in our industry since the day the law was in inception, and has done her best to abide by our laws. And furthermore, come and spent her time and efforts to serve on this board to help enforce our laws. I realize that does not change the fact that if she has a bill due, she has a bill due, and she's responsible for it. I think that a person that has served in our industry the way she has, as a respected person, if there's anything that we could do for her to help in this situation, we should.
I agree with Keith, but here's my question. Can we?
That's my question as well.
If Mr. Harvey, if you would like to make a personal telephone call to Miss Jones, you're free to do so. As a board, no. You are held to the statute. I'm legal here.
So
I
what,
agree with that.
to rephrase, and Ashley, correct me if I'm wrong, legally, we cannot grant what she's requesting.
No, you can't. Based on what this email says, you don't have the authority to extend an.
Please convey to Ms. Jones that the board has great sympathy and understanding, but legally, we are bound and what she's requested.
This does ask for it does say, please extend my QA replacement for 30 more days. Has she had,
It's your
Yes, sir, that's what it says, but that is not after
she
about.
didn't give notice of her qualifying agent leaving.
She has no qualifying agent, sir. She is the qualified. It's just on
Right.
one
I
person.
think what
company.
happened, she didn't pursue the requirements to renew her QA license, thinking that her company was possibly going to be sold, and now the company, for whatever reason, did not sell. She's not met the requirements to renew her QA license, and she's trying to come back and do that on an extension.
Using the wrong terminology.
So-
Well,
After
yeah.
different
I don't think
conversations
she's
with
trying
Ms.
to
Jones.
replace her QA.
No,
She's
she's-
trying to get caught up to renew her QA.
Right.
So when does her company license expire? Wouldn't that be the,
Well, even if she didn't expire for a year, as far as the company license, she can't operate without a qualifying agent is the issue. It's not, I mean, would be relative if that was also expired, I guess. But if you're thinking, well, she doesn't renew for a year, she still has to have a qualifying agent the whole time.
we can't give her an extension for not having a qualifying agent?
We've done that for a lot of people. It is just that the way this really isn't, that she hasn't sent in a letter saying, I no longer have a qualifying agent.
Right, those are two different things.
Right.
But we have,
Replacing the QA, of course, you all have the authority to do that, but from what I can tell, reading the question, it's more, I'm set to expire at the end, well, I will be outside of grace at the end of this month. Will you extend that 30 days? And the board just doesn't have the authority to do that.
so does she still have to the end of this month to,
She's still within her grace period.
okay.
So she would just do the renewal with the late fee. If we get to March, she would have to reapply.
Her company license expired November the 30th as well.
So she has till the end of the
And then she's in the grace period, then she would have to reapply. Wait a minute, let's. Stand corrected, excuse me.
Company is
It's
current.
been a while since I worked that yet. She's good to 2020 for the company.
For the
Just the
company.
we're only talking about her license.
Have you explained to her that if she pays the QA and the picture, then she's
Well, she
good
says
to-
that in her email, and that's all she needs to do, because she says she's got the CEUs.
But I mean, have you explained to her that legally, that's the only way that she can renew her license, that,
Madam Chair, I have spoken to Ms. Jones on numerous occasions. I couldn't relay everything I needed to, apparently, to her for her to comprehend, so I said, well, you're just going to put it in writing. Come before the board, you come before the board. That is financial restraints on, so she couldn't do that, so she asked me if I would present a document, and I said, of course I will. Anybody that asks this, I will do this. But yes, she has been explained. If there is something that you might want to reach out and assist with as a
private citizen.
private citizen, thank you.
Gotcha.
Feel free.
It is what it is then. What do we need to do here?
I think Madam Chair has already explained that I just need to send her a nice letter saying that it was presented to the board. I'll try to contact her today if at all possible. Of course, her time is running out.
and that as much as the board wants to help her, that legally we're restricted from granting her request.
I would love to help her, but it's like we can't, when we.
That's what I say,
Yeah.
legally, we're restricted from doing what she's asking us to do.
That's why I said if any of you need a telephone number or anything, I mean, she was a former out as a concerned individual, you may do, of course. Can't say as a alarm member.
Anything as a board member.
Right, cannot represent yourself
As an
a board
industry
member.
person or private citizen, but not as acting on the board, as a board. Okay.
All right, I think we got that. We're going to go into our criminal. First one should be Exhibit A. I do need to ask legal, which I have forgotten to do this. According now to the new statute, if an individual asks us for a copy of their criminal record, we must oblige them.
No, that's not the way. What is the request for their criminal record?
Yes.
They can contact the FBI or TBI and pay the fee and
I misunderstood also. What the question I was going to ask, if that is the new statute that they can obtain their own, or that I am
You're required to
not give it
them?
to you, is really what I was asking, but that's okay. I would just confuse that situation.
Yes.
Probably did.
Can we
I do
start
I do.
over?
Let's just start all over. Let's go to Exhibit A. I'll have to give it legally to an individual
the board can always
can
review it. Yeah.
never give the board the criminal record. No, you have never gotten this TBI.
We've gotten criminal histories. I
You
mean,
get
you
criminal
can debate
history
the
that
format
I
of
make
it,
for
but
you, yes, but I'm talking about presenting all that. So we'll just go like we normally do, and I'll look that up and make sure it's correct. I don't want to.
Going back to the future or something on this.
Okay. We have this individual who's a registered employee, working for a monitoring, it would be a monitoring representative. That's something you always ask me there. Have, no, that's not the one I want. That's insurance. Have an explanation, as which is also attached. You have a document, a court document about the probation to review. Charge she was fingerprinted for is aggravated battery, classified as a felony. That was on 8/8 of 2018. As a board knows, I can look at the criminal records if they're 10 years old or older, and it's a new charge. But it has to do with insurance about the vehicle, so I just wanted to tell you the felony.
other state. Duh. I skipped the last part of it.
We all do that.
Oops. I read the
Have y'all had an opportunity to review this file?
I would make a motion.
Oh, you make that motion, Mr.
Yes.
Harvey. Let's go. I'm sorry, excuse me. It says that she was arrested for the aggravated burglary, but if you look at what she got.
She was arrested for aggravated assault, but she was charged with endangerment. I think the thing is there was a gun inside the glove box, and there was a fight outside the car for over an hour, which is unrealistic. And she claims the gun remained locked in the box, but the police obviously had reason to believe that the gun didn't remain locked in the box, but they did reduce it to an endangerment, which is a Class A misdemeanor.
Okay, that's what I wanted to, I was having a little trouble reading that myself.
Yeah.
Because when it comes back in and says aggravated battery, unknown circumstances, then I get the parole documents and the other documents that said, looked like it was reduced down from the court, reduced for, endangerment, 3 counts, must have been 3 children perhaps.
3 girls, yes.
Okay, 729 is what I understood. So they reduced it from a felony to a misdemeanor.
And in December the 14th, I believe it was, they granted her probation for 12 months.
Right, it's going to expire 12/14 of 19. Excuse me, Mr. Harvey, I just wanted to make sure I understood.
Well, that's okay.
I would make a motion that we not grant Miss Hever, however say that, due to the newness of her criminal history and the fact that she's still on probation.
Hey, we have a motion by Mr. Harvey to deny this application for employee registration based on her criminal history. Do we have a second?
Second.
And we have a second by Mr. Cockcroft. All in favor, voice by saying aye.
I'm sorry, before the board votes, if you're going to deny it based on that criminal conviction, we have to go through the fresh start factors on the record to discuss factor in the denial. Give me just a second and I'll pull that up. So the first factor is the nature and seriousness of the crime for which the individual was convicted. I believe we said this was a endangerment conviction. So I'm assuming the board feels that is serious enough to deny her licensure as, what was she, as just a registered employee? Okay. The length of time since the commission of the crime, I believe Mr. Harvey already acknowledged that she's currently still on probation. If I can get the board to discuss the relationship between the nature of the crime and the ability and fitness to perform the duties as a registered employee. And how you feel that this particular conviction, I guess, reflects poorly on her character and fitness for the registered employee profession.
That the fact that she has been arrested and is currently on probation for a serious charge of endangerment, even including a weapon, and
I think that probably also goes to the reason that we regulate the alarm industry as far as protecting the consumers. So because that's now on the record, we can include that in her denial, and we've complied with the law. So I'm sorry to stop your vote, but
We dismissed the relationship because we thought we had it covered with the fact she is on probation, the seriousness of the crime, and the time span since the offense occurred. We just didn't get the part in there about the relationship to the industry. So, okay. We have a motion by Mr. Harvey. We have a second by Mr. Cockcroft to deny this application of employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. And you can get it from the court reporter as to the relevant part for the fresh start. Okay.
Okay, we can go now to Exhibit B. This individual is also a registered employee, service technician. The one I wrote on. I don't have the papers I wrote on. You have a written statement from the individual. You should also have some court documents from Cheatham County Court for charges.
Oh, I do not know this person personally. I just realized that he is with my company, so step out on this one.
You can let the record show that Keith Harvey he recused himself. As you can see on these, this is mostly drug-related injury. Document, he was even referred to a drug program. The charges may be old, but there were so many of them, I just felt the need to bring it for the board.
I'm going back in time.
It's okay. So he, according to this, he is not on probation, correct?
According to
We don't have any charge documents to look at.
No.
It's just some type of a printout.
Where did this document come from? I mean, I see it says,
the individual himself provided
okay, so
it.
he provided that.
Oh, yes.
And then you see on the TBI report, same information, but, and you look at that to make sure it's the same information, that there's not something else, I guess, on.
Well, usually I have a lot more on the record than I have on the court documents, but a lot of what I have has all been dismissed or null, so there's you wouldn't need to be looking at it. But since he did supply the document itself, I always include those in the packets.
Vest, you mentioned that he completed a drug treatment program successfully?
It looks like the court asked him to go to a drug treatment, but I don't have the document.
Oh, I thought, I misunderstood. I thought you said he completed a drug treatment.
Excuse me. Okay, it's looks like it's 2009 conviction, confinement, or fine, may be furloughed to a drug treatment in lieu of the charge, or released from. But we do have a question that asks, have you ever been, I forgot. Or it may not be on this application. It's on my paper application, we do ask. If you are, have you ever have been committed for drugs or whatever, we have to have the court document that says you have, especially if it's been by a judge, and then we need the document from the judge that said you had been released. But I don't have that information. I just have the criminal background on it. The more information you want me to get from the individual, because his explanation was just, didn't give a very good explanation. Didn't address any of the actual offenses. I can table this one, take another look at it, ask for a better.
I would feel better with some more information, or requesting him to, I mean, you could offer that he could come to the next meeting.
We're not denying it, we're just
Not
not
to the
approving
next
it.
meeting.
Correct.
Yes, because as long as the individual has the application on file, has not been denied, the individual can continue to work. We're not going to prohibit him from. If you'd like to, if you're ready, we could move on to Exhibit 3. Also, a registered employee. Which was going to be a sales rep. I'm going to skip right over the criminal record. And go right to the. Go right to it's fraud from what I could see, fraud for a credit card. And a 23-year-old man made the irrational decision to forge information in pursuit of a college education. I have the document here to where it looks like it was diversion. And then you see on top of it, it says amended judgment.
They terminated the diversion.
Yeah, they terminated the diversion, and this is classified as a felony. This document right here is easier to, probably for you to see and read.
Must have had 4 charges against him according to the docket numbers.
The explanation is basically nothing.
Right.
What he is asking to be licensed to do
Registered employee as a sales rep.
as a
yes.
sales rep with credit card fraud, in-home sales, because that's what this company would be doing.
That seemed very relevant to that.
That's what concerns me. That goes back to the Roy of him explaining the contract.
I make a motion to deny the applicant's application.
Fresh start it. to include.
And so I think that they've hit on probably the bigger points. I think the only one that was not discussed was just the length of time since the commission of the crime. I think that's the only one that the board on the record.
I believe it was 2000. That goes back to 2005.
I see a 2007 stamp.
It looks like the judgment was 2007.
2007, yeah.
And then he had 2 years probation, so that would put it at 2009 when he came off probation. That influences the board one way or the other. If you think that's not enough time since the commission of the crime to lean towards granting the application, or if you think that the seriousness of the crime kind of outweighs the fact that he came off probation 10 years ago, just have that kind of discussion on the record, I guess.
My feeling is that that is not sufficient as far as a time frame. Of course, he would have the applicant would have a right to come before us or dispute that if they want to bring some other information. But looking at this, the number of charges and the explanation, even in light of the amount of time, dealing with contracts and credit cards and people's financial information, to deny.
Okay, we have a motion by Mr. Cockcroft to deny this application for employee registration,
Second.
and a second by Mr. Fraker. All in favor, voice by saying aye.
Aye.
All opposed? It's denied. Of course, tell him if he wants to come before the board, we welcome
Yeah,
him.
under that Fresh Start Act, they have, so many days to appeal, and that would be told to the individual when we do the denial, the process.
Okay, the next is the education.
I'm sorry,
report.
Mr. Harvey, excuse me, Chair.
I was just going to say that's a good example. That may be one of those cases that may be looked at differently in person because of the length of it. No, I think it would serve him well to come and talk to us.
Encourage him to come before the board.
I'm still going to send him a denial,
Yes.
and he has the right to appeal that, which means he has the right to come before the board and present his case in person.
But, yeah, and if you were to have communication with him, just tell him his explanation was very brief. We don't know what he's been doing in the last several years. The board wants to hear more about him, but as for now, it's been denied. Education.
Good bit of it.
I always trust y'all on these.
One of them days. Okay, Lou, I think we could probably start with you. You have the Alarm Academy LLC Electronic Security Technician Training.
That is correct. Looking at the syllabus, I don't have any issues with it. I think it looks like it's a very, of course, closely related to Level 1 technician. The only problem I did see is that as far as documentation on the app, they requested 24 hours. On the certificate, they documented 23 hours. And I could only find 23 hours, so we can approve it for 23 hours.
All right, we'll put it on the record and change it to 23 hours if it gets approved there. Now, are you telling me it's okay for all three? They wanted employee, initial, and continuing education?
Yes.
Is it it's one course for all of it, or is it a combination? Sometimes they'll submit like multiple classes and they all add up. I was just wondering if it's one class.
course.
Okay.
It's one course.
So it sounds like it would definitely, be applicable for continuing ed and employee. And you say it's comparable to level
Initial,
one
yeah.
for initial.
Qualifying agent?
Yes.
Now, in the past, haven't we wanted something proctored or something for that, or either a video proctor or for the initial training?
Yes.
This,
Is it?
So.
It says it's going to be administered in person.
okay.
It says
Yes.
the Alarm Academy, this course will be administered in person or online and contains 22 hours of industry-related material, followed by a 2-hour comprehensive exam.
So that goes back to 24, 22 and 2, somewhere along the way their
In the
math.
documentation, though, I could
No,
only find
that's what she
23.
just read.
Oh, yeah, so,
Well, they're including the 2 hours of the exam. See, it was 22, then it was 24. No, we had 20, Lou said 23, yeah, then they're saying 22 hours, and then they're going to give a 2-hour exam.
right. On the syllabus, though, with that 2-hour exam included, I could only find 23 hours.
And the certificate
Right.
itself says 23.
Right.
Yes.
They do
So
also
I
allow
changed
time
it to
for breaks
23.
and other stuff. I don't know if that's included in there, but.
Well,
We're
it's
gonna go
50
with
minutes,
23 hours,
so
though.
it's considered an hour.
All right, so we are going to take the Alarm Academy LLC, we're changing it from 24 hours to 23 hours, just as the certificate says. If they come back, we'll address that again. For employee, initial and continuing education. All right.
Would we need to do something conditional, though, on the, because if they're doing it online, then the test wouldn't be proctored. I mean, if they do it in person, it would be proctored. Because some of the other people that have classes have like a video proctor, or they've done other things for the initial training.
The ESA tests you can do online, but you have to go to PSI locations.
They've changed that now. Now you can do them at.
That's my only concern, is if we let it be an
They do
online class
video
without any
Confirmation.
proctoring.
They don't say that. They don't state video confirmation in the syllabus.
We would have to strike the online.
I was looking to see if they were, maybe I just didn't understand it, if they were a provider, but I don't see them on the list as a previous provider at all, either. Well, what are you asking me to do? Go back and tell them we would approve it. It says in person, but online, how is it proctored? Is that what you're asking?
Well,
or what?
they would need to submit proof on how the online test is proctored. But we would have agreed to approve it for in person at 23 hours now.
23 hours, yes.
And the hours, I think, aren't an issue, because isn't it 16-hour, what the initial training, how maybe?
Or I was writing. Could you repeat that again, Scott?
I was just rambling. I wasn't sure if the 23, 24 hours
We can
mattered.
actually make the motion conditional if they provide sufficient proof that their online training is in fact proctored. I wouldn't have a problem with
And
going
approving.
ahead with it. If, you know,
Okay,
if
if I get
you're
proper-
satisfied that it's verified, proctored, however, online to allow that training in that format, but just go ahead and do a motion on this one since it's a little bit complicated before we move to the next.
Already have a motion as it is, right? Or,
I don't think we do.
oh, we don't?
I think we've just had discussion. We need a motion to approve it.
I would make a motion to approve the Alarm Academy LLC with the condition of a proctored exam, either online or in person, for the employee and initial training. I would approve the continuing ed, but it doesn't need to be proctored.
And for 23 hours.
And for 23 hours instead of the 24 hours.
Okay. We have a motion by Mr. Cockcroft. Do we have a second?
Second.
And a second by Mr. Fraker. All in favor, voice by saying aye.
Aye.
And this is for the Alarm Academy LLC, by the way.
Very good. Doug, we'll take yours now.
right.
DEI Security Solutions LLC.
Correct.
Doing business as Security 101. They want 2 hours continuing education and for employee.
Actually very interesting to read through it. I liked it. I was glad that they actually submitted what they're talking about, and I have no problem granting 2 hours of CEU.
But what about the employee?
Well, employee training, yeah, that's fine too.
Well, it's another one of those things where I think the employee training has to be a full course, right? They can't submit an hour here or there. It has to be a complete course. That's how the other one was. It's rare that someone actually submits a course long enough that it can be the employee training or initial training.
Well, they don't ask for initial training.
Right, but it's good for continuing education, but it wouldn't be for employee because it's not it's not enough hours. You would be saying they could take a 2-hour course, and for the initial employee training where they have to take something equivalent to level 1. Typically, we haven't approved anything that was less than.
So to get clear to me, employee training is to get the level 1?
Right.
Then what's the initial application?
That's to be a QA, which it is the same. I mean, that is the same test sometimes, or same.
Okay.
It's that the QA then has to go on and pass an exam that the board approved. But yes, the same level 1 could apply to an employee or the qualifying agent.
Okay, my misunderstanding of what the employee training, I was
Be a long
thinking
time
in my.
to get that too.
I was just thinking of, just as a general training employees.
I believe it states that you're supposed to have your employee trained within a year.
Right.
So
Well, they're supposed to have a level 1.
within that, yeah.
Within a year.
Is that what you're saying?
But I was.
Good for?
Yeah.
It wouldn't, because
Would
it's
not.
only a 2-hour class. It's not
So-
it's not enough of a class for the initial, or for the employee training or the initial training for a qualifying agent.
So you're recommending it's for continuing education only?
Right.
Okay.
Yes. I agree.
Okay, we need a motion.
I'll make the motion that we approve the course for 2 hours of continuing education only.
Second.
Okay, we have a motion by Mr. Fraker, a second by Mr. Cockcroft to approve the DEI Security Solutions for 2 hours of continuing education only. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. And then the next is
I had the
DITEC Surge.
DITEC, and it's a good class as well. It's a lot of information and definitely applies, but there again, it's a 1-hour class, so it would just be for continuing education.
Hey, if you've looked at, I don't know, do you have the list of everybody's, or do you have just your own?
We have a list on the computer, on the iPad.
Because the first one that you've already approved, and this one we're discussing, and the third one, they also want to be approved course provider and course instructors. We just approved the course for the
Right.
employee or QA or whatever.
And sometimes people provide that, but have we been approving providers as well? I mean, the trainers as well as the class?
How to get on the course list.
Okay.
Oh.
Did they send something different? Okay, I just didn't go back far enough. The individual here's his resume. We're talking about the one that you have, of course, Doug. Here's his resume in the back. If you look at your iPads further back, here's the documentation for the course. and for the provider.
That would be known as Jeff Bolden.
Is there a separate application for a course provider? To approve a course provider, or no? Gotcha.
I've always looked at, the resumes and stuff that came with it. I just thought usually we were approving both. When we were approving the class, we were approving who they were presenting.
Make sure we have new board members. Eventually, I get to tell you you're all old board members.
Then they disappeared.
I'll just kind of hang around, you know what I mean? Which we are so grateful.
Okay, go back to the first one, the Alarm Academy. Lou, you had that one, correct?
Yes, they were.
Did you find the instructor and the course provider
Yes.
to be acceptable?
Yes, there were 4 resumes, I believe, attached to that one,
Okay.
and they all looked fine.
Scott, you had DEI, correct?
I had DITEC.
Okay,
I
Doug, you had
DEI.
DEI.
I see no issues with their resumes.
Okay, so you're okay with them. And then Scott, you had DITEC, correct?
That's just where
We didn't vote on number 2, though.
They did.
Oh, we already.
We voted.
We
Doug
voted.
and
We're
Scott.
ready for the fourth one.
Okay, that's, okay. It was Doug and Scott, right? That made the vote.
Yes.
The nomination. Okay. I just wanted to make sure I got on record for everyone that it was also, we're going to put them on the list as a course provider.
What does that mean,
Let's
though?
just make a motion that we approve those courses, since the motions only covered the courses and some were modified. We just make a motion that the Alarm Academy and its instructor, DEI and DITEC, be accepted as approved course providers and instructors, and then we're covered.
What are we approving them to do anything other than these courses, or just the next time
They're going to, no, they're going to get on the course list. We're going to be for these courses, but if they're going to teach more courses, the course is going to come back to you, then you're not proving
They
their
wouldn't have
company.
to resubmit the resumes
No.
of the trainers.
Once they get on the course list, and
Okay.
the trainer, whatever, I'm just going to bring back the course to you. That's why these are a little different. Because if you look at the last one, it doesn't
not
say
there.
anything about the course provider.
Okay.
Okay, I'm fine with that. I'll make a motion to approve we're to approve all of the trainers and companies as far as to be course providers in the.
Got a motion by Scott. As you want to list them by name, just in case? Alarm Academy, DEI Security, and DITEC. We have a second on Scott's motion,
Second.
and a second by Mr. Fraker. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries. Now we're ready for AI phone?
Phone, that's how I did, AIPHONE.
Artificial intelligence, probably.
They say it a phone. I don't.
Is that how they pronounce? Well, I want to make sure we got it
Artificial
on the record
intelligence phone.
correctly
But they,
spelled.
it doesn't look like that though.
When the
Okay.
iPhone was created, there was no such thing as
An iPhone.
artificial intelligence.
What is that just the name?
They
of it?
the name
are
of
on
the
the,
company.
they're already on the course list, approved course list. But with this one here, they said, I wanted to discuss this one because they say all of the above. They want it for employee initial continuing education.
I think
So,
we've just been doing those for continuing education, haven't we?
So this is a little different. I was a little confused the way they wrote this. They want number of hours, 1 for alarms for Berg and 1 for monitoring. But if you're telling me that's not enough for a qualifying agent, or
Who
determine
looked at
what they
this one?
wanted. Alpha, this one here was Keith.
But I am here, praise the Lord.
Well, it just shows,
Hey, here's this,
this just says 1 hour.
Yes, it says 1 hour, and it says Berg,
And we haven't,
then all of the above.
and we haven't been specifying, we've been accepting a CEU for, across the board. We haven't been specifying for a category.
And I don't know
Well,
that there is a
They would normally
classification.
ask us for what, employee, initial?
Right, but there again, it wouldn't be for employee or initial if it's just a 1 hour class.
Would just be for the continuing education?
Correct.
Well, let's just give Keith a minute just to kind of peruse that a little bit.
Didn't know what they was doing when they checked all of the above.
Right, it was a little confusing there.
I think everybody just figures they'll ask for everything and whatever gets
And
approved.
we'll just figure it out.
Yeah.
Whatever we'll give them, they'll take.
All right, so while Keith is looking at that, I do apologize. Could we go back to the one that Scott had? Did you approve, we said for continuing education
Yes.
only?
Yes.
I want to make sure, because I have to notify these
well, the one
individuals.
that had the 23 hours.
No, I'm just talking
No, the one that had the 23 hours, we approved it as it was
All of
submitted.
them, right.
The other two, we changed to continuing education only.
Thank you for that clarification.
I would rather it be entertaining as be like a funeral parlor.
But I'm always entertaining.
Well, this is a highly intelligent group of
There you go.
professionals that I have on each side of me. Their imagination has to be sparked.
There you
Otherwise,
go.
they grow
I'm an
bored.
imagination sparker.
But you have to, I mean, they're so intelligent, you have to stimulate them or otherwise you get nothing, so.
There was this one time.
Really?
Oh, really?
Was I
He said, well, there was this one time.
There's plenty of times.
I'm very familiar with the iPhone product. It's something my company uses a lot. All of these are for 1 hour, and they've only marked Berg and monitoring. I don't see why that wouldn't go in a fire category as well, honestly. If they
Do you have to specify for CEUs, which category? I thought we
they only marked it for that. That's why I'm.
because we eliminated the employee and the initial from the,
Yeah, we're going to have to see that.
I think we're just approving those,
Continuing education.
correct.
For a 1 hour course, yeah.
1 hour, okay. So on the record,
I think
I
he's
know,
going, he's
but
going
for
to make a
iPhone,
motion.
we are looking at only the continuing education that you looked at. Thank you.
Well, we've already done the others because they were so confusing this time.
I make a motion that we accept the iPhone classes as continuing education for 1 hour each.
Second.
Pick one. I don't care.
We have a motion by Mr. Harvey, a second by Mr. Fraker to approve the AI phone for continuing ed 1 hour as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Course review,
That's what we just,
oh, it's under education report on mine.
yeah.
We don't have it.
So let me just ask a question. I want to clarify, when I review these education submittals, if there's a resume attached, then they are asking for a course provider approval also,
Yes.
right? Because I don't see anywhere on the application where it indicates that at all, unless I'm missing it somewhere. So, okay,
Well, usually
cool.
they'll send us correspondence, says we want you to present we want to be a course provider, we'll add our company to the course list, and here is our instructors, because they have to give us the resumes. So we make sure that they can teach the class.
good enough.
Okay. Do we have any unfinished business?
No, I do not.
Business?
No, ma'am. Don't. Everybody's got, make sure you already got your list for all your board meetings for next year. Took care of all your dates, your hotels. Parking has been provided for you. Everything's okay.
All
right.
good.
You just jinxed it.
We'll see you in April. This meeting is
What are we doing?
adjourned.
All right, thank you.